We are so excited to welcome from Logic Wealth Management for a presentation on the financial aspects of estate planning, Mr. David Chung. David, please take it away.
Thank you, John, and good morning, everyone. I want to thank everyone for joining us today as an investment advisor. And let me start my PowerPoint slides. So just to provide you with a little background about myself and our company, Logic Wealth Management. So we're a fee-only investment advisor. We're located a couple blocks from Lacera's office in Pasadena. As an investment advisor, we manage currently just over $220 million for our clients, and all our clients' assets are custody at Charles Schwab. The unique thing about us as investment advisors is we choose to be a fiduciary, and being a fiduciary, it requires us to provide investment advice that's in our clients' best interests. And the other unique aspect is our expertise. We have assisted a lot of clients with the County of Los Angeles, both retired and active over 20 years. So in this case, we've had this discussion with numerous clients and their attorneys. And when RELAC and Debbie and John asked me to give this presentation, I was very honored to provide it. So let me start with the first slide. More info about our company. Like I mentioned, we're investment advisors, so I'm not a licensed attorney. Our firm does not provide legal advice to our clients. We provide investment, financial planning, and holistic advice to our clients. So our advice to you is, after this presentation and anytime you have questions regarding estate planning, consult with your attorney for legal advice. One of the reasons why RELAC asked us to give this presentation is we work hand in hand with attorneys and our clients in regards to their estate plan. We basically coordinate everything. We have a very intimate and thorough understanding of a lot of our clients' finances, and that helps the attorney, that helps the client with the estate planning process. I was mentioning to John before this presentation that after this presentation, I am actually going to a meeting with one of my clients and their estate planning attorney to discuss their estate plan. So it's perfect timing because we have these discussions with our clients on a fairly regular basis. So the question that we get from our clients pretty much on a regular basis is, what is estate planning? It's a very great question, and for today's agenda, I'm gonna cover generally what an estate plan is, and specifically for this webinar, a lot of our county clients ask us, Dave, do I need an estate plan? I'm a current active or I'm a retired LA County employee. I have special benefits like Lacera. Does an estate plan actually benefit me? So we'll cover that part of how estate planning and how your benefits, being an active or retired LA County employee and having Lacera benefits, if an estate plan would benefit you. And then we will also cover the benefits of a living trust, which is a big component of an estate plan. Some estate plans might have a living trust, some might not. It just depends on each client's or person's financial situation, personal situations. We'll also briefly get into the tax implications of estate planning, the benefits of asset protection with an estate plan, and then I'll briefly cover, I'll summarize it and cover the next step of after what to do once we're done with this webinar. What is an estate plan? Just generally, an estate plan is a process of just arranging your financial affairs. And with an estate plan, it allows you to establish your wishes and preferences on how you like to basically pass along your assets. With an estate plan, for us, why it's very important is it minimizes the legal complications, and also makes it very I guess cost prohibitive, where you're able to save a substantial amount instead of going through a process such as probate. And overall, the most important thing with an estate plan is it provides financial actually security for your loved ones. So Like I mentioned, since this is a presentation for RELAC and LA County employees, I want to cover this slide in particular, which is the majority of County of LA's employees and their spouses have LACERA, and we tell this to pretty much all retired and active county employees during the meetings that LACERA. I joke and I say LACERA is gold. There's nothing better than LACERA, because if you choose the appropriate LACERA pension option, you could have a lifetime annuity, and in the event of your passing as a LACERA retired or active employee, your beneficiary could receive possibly lifetime benefits as well. So when we do our analysis, there's really no benefit that's available for retirement better than LACERA. And LACERA itself, we often attend meetings with a LACERA specialist and our clients. So we're very familiar with the process, and the specialist can provide any current or retired LA County employee with a LACERA. It's called a power attorney form. We highly recommend that you obtain the power attorney form and basically sign it. Name your power attorney, which could be your spouse or another family member or friend, and make sure it's approved by LACERA because it's their form, and have it on file. Because with that form, the person that you appoint as a power attorney is able to make decisions on your behalf, depending on what authorities you provide them with. The other reasons why most of our LA County employees need an estate plan is they have other assets. We often joke with our clients that their biggest asset is actually the LACERA pension, because oftentimes the LACERA pension pays them for the rest of their life. It's a monthly pension that's as a lifetime pension, and oftentimes their spouse gets a survivor benefits. So like I said, nothing is better than LACERA. We always say LACERA is gold, but in addition to LACERA, a lot of our clients have real estate assets. So if you have real estate assets, having an estate plan and having a living trust, it's crucial. We recommend all clients that have real estate to have a living trust, which is, like I said, a very vital component of the estate plan. And in addition to having real estate assets, if our clients have children or special needs children, then having an estate plan with a living trust, it's a must for all of our clients. And when it comes to special needs children, then that's where we'll discuss it with our client and their attorney, and we'll often discuss what's called a special needs trust, which is even more specific than a regular living trust. So like I said, I'll cover this in this presentation. I'll cover the general aspects of this, and then in the Q&A, if you have any specific questions, I'll do my best to address it. So the financial, are a lot of times our clients ask us, Dave, what's the financial benefit of having an estate plan? With an estate plan, I think the two biggest benefit or three biggest benefit is protecting your beneficiaries and loved one, to ensure that who you want to receive the assets actually receive the assets. And then also, just as important, it's going to help your family or beneficiaries reduce their estate taxes. And then for example, if you have a real estate property and it's not, and you don't have a living trust, or your real estate property is not titled in a living trust, then you will probably go through a process called probate. And probate, unfortunately, takes a very long time, and probate also it's very expensive. So we often recommend for our clients to protect your wealth for your family and future generations, to have an estate plan. And with an estate plan, which, like I said, often includes a living trust, it's a very efficient way of transferring assets, where the assets, whether it's a home or other accounts, gets to your beneficiary that you intend to receive it, and it gets to them in a very efficient, timely manner, and the cost of them receiving it is very minimum. The other benefit, possible benefit of an estate plan, is it also provides liquidity to cover some of the expenses. So in this case, the other question that we get often is when it comes to an estate plan, what if you don't have an estate plan? What are the issues with not having an estate plan? So we tell our clients, if you have an estate plan, it'll allow you to minimize or avoid probate delays and costs. Uh, Something that's very important to a lot of our clients is that with an estate plan, especially a living trust, it provides privacy. Where with a living trust, it doesn't state, it's not public record, so the public is not able to find out what assets you own and who's going to receive that assets. Um, and like I mentioned it before, well, with an estate plan and a living trust, it allows a smooth transfer of these assets. And it allows, in this case, I mentioned with the power attorney that Lacera provides, an estate plan, a comprehensive estate plan, which includes the living trust, possibly another set of financial power attorney, a healthcare directive. It allows for the management of these assets during times where a lot of our clients, and we always joke, if you work for the county for 30 years, we want you to enjoy your Lacera benefits for 35 or 40 years, but during these times, unfortunately, we might become ill or incapacitated, and that's why it's very beneficial to set up an estate plan. So in an event where you're incapacitated, you're in a hospital, you're overseas, you cannot be reached. That's where your family member, depending on how the estate plan is written, they might be able to act on your behalf. So, and we always tell our clients it's always best to have to establish an estate plan and living trust if needed as soon as you can. Our joke is just do it before you die. And we jokingly say that because unfortunately none of us know how long we're going to live, and having an estate plan provides you with the flexibility. You can amend it, you can revoke it, and us as investment advisors, we since we have a holistic and understanding of our clients' finances, we would often discuss their estate plan. We would review their estate plan, and some of the assets. For example, a lot of LA counties employees either have I'm very familiar with the county. So when I started helping county clients back then, it was called Horizons. But in Great West, which is a parent company, they rebranded to Empower. So nowadays, when I talk to county employees that have been with county for a longer time, and I mention Horizons, they know what it is. When I mention Empower, they some of them always keep in mind Horizons. So, and for the new employees, they aren't familiar with Horizons, but Empowered Horizons is basically the same brand. Empowered Horizons is basically what they're the plan administrator for LA County, and they're the ones that facilitate your 457 plan or your 401k plan. So a lot of times, depending on our client situation, you might need a living trust or you might not need a living trust, because sometimes you're able to basically name a beneficiary for your 457 or your 401k, and that might be sufficient or it might not. It just depends on your situation. But we always tell clients, you should have an estate plan, and like I mentioned, it might include a living trust or it might not. And in addition to your estate plan, if you have a good financial advisor or investment advisor like us that's a fiduciary, then you can have that discussion. And our clients will often ask us, hey, Dave, for my Empowered Horizons 457, who should I name as beneficiary? So a lot of times we have the discussion where generally, if you're married and you have a spouse, most of our clients would name the spouse as a primary beneficiary for the 457 or the 401k. And then the second question that we often get is, okay, Dave, I name my spouse as a primary beneficiary for my 457 or 401k. Who should I name as a contingent beneficiary? And see, this discussion gets more detailed where, depending on your situation, oftentimes it might be beneficial for you to name your living trust as a contingent beneficiary. It just depends on your, like I said, your personal and financial situation and basically your goals. So in this case, these are a lot of the reasons why we recommend an estate plan and a living trust. So a lot of times for our clients, having asset protection and having all the other benefits of an estate plan and living trust is very important. But for them, it's also a big financial decision, and that's where we at Logic Wealth Management, we're an investment advisor, we're fiduciary. My partner is a CFP and an enrolled agent, and he gives tax advice to our clients. We actually don't provide tax services. So we don't help our clients with the actual tax return, but Hung, my partner, that's a CFP and enrolled agent. He often would review our clients' taxes and we'll help our clients with estate planning. And when it comes to tax planning and estate planning, a lot of times they come hand in hand, where there's a potential reductions in estate and gift taxes with an estate plan. So that's why we often recommend having a estate plan, having a living trust, so you can minimize those costs for your beneficiary and for your estate. And there's a lot of different strategies to minimize capital gains and other taxes with an estate plan as well. And that's part of the discussion that we often have with our clients is, depending on your financial situation, we often advise our clients to provide charitable giving benefits, such as donor advised funds, and all this planning for our clients, this investment advisory planning, this financial planning, and overall the holistic wealth management that we provide helps our clients maximize and preserve their wealth. So when it comes to asset protection, depending on how you establish your living trust and estate plan, it can provide some safeguards against creditors. It definitely would help your beneficiaries in terms of inheritance, and minimize their costs and time in receiving the assets. And for us, the most important thing is it provides the financial actually stability for for your beneficiaries to ensure that they have access to the assets, to the financial resources in a time that they need it the most, which is unfortunately for a lot of our clients, after the client's passing. So, and for a lot of our clients, we often joke that since especially LA County clients, that since LA County clients have Lacera, most of our LA County clients are very fortunate with our assistance in planning their finances and managing their assets. That we our joke with them is they're never gonna spend all their money. So that's why an estate plan, and often, like I say, living trust would help in this particular area, where it ensures the legacy to continue across generations. Because most of our LA County clients, with what they receive, from their Lacera pension, sometimes their Social Security benefits, sometimes their other assets, they're going to be very comfortable for the rest of their lives. And so they often ask us, "Hey, Dave, I have, my 457, I have my 401k, I have my, properties, I have other assets. How do I ensure that my beneficiaries receive those assets with as little cost as possible, and also there's no delays as possible?" And that's why an estate plan and living trust is very important. So to summarize, when it comes to estate planning and actually having oftentimes a living trust with your estate plan, it's very important because like I mentioned during the last 20 minutes, that an estate plan, and often with a living trust, it provides significant financial benefits. In particular, with a living trust, it streamlines, the wealth transfers and reduce costs, especially when it comes to real estate, where if you don't have if you own a real estate, and since most of our clients are in California, when we talk to them, we often advise them to speak to a California attorney, but we have clients in other states as well. And our general understanding is, whatever state that you reside in, and often times whatever state your assets are in, that's where you should contact an attorney in that particular state, because most attorneys are licensed in, like we have a few attorney colleagues that our clients often use that are licensed in California. So if our clients live in California, we often refer our clients to those estate planning attorneys. Where we have other clients in Arizona, in Texas. We have a lot of clients overseas, in other Nevada, other parts of the states, and that's where we often would help our clients coordinate an estate planning consultation with an attorney that's licensed in those particular states. Because we recommend for our clients to hire the attorney that's licensed in the client's particular states, because each state has its own tax laws, has its own legal laws, and most attorneys they will not be comfortable providing estate planning advice for a client in a state that they're not licensed in. They often would have a referral for you. So we highly recommend that our clients talk to a financial advisor or investment advisors like us. And with some of these estate planning attorneys, for example, the estate planning firms that we often refer to clients, they'll provide our clients with a free consultation. So estate planning can get very complex, and that's why I often recommend for our clients to sit in a consultation, whether it's in person or Zoom, and then once they receive the consultation, we'll have the discussion with our client, and at some point, if they have additional follow-up questions, we'll recommend that they either receive another consultation from the same attorney or get another consultation from another attorney. Some of our clients have had some negative experience with attorneys. I often joke with our clients that it depends on the type of attorney that you have experience with. For example, if you're being sued, your experience with attorneys probably going to be negative, especially with attorney that's representing the plaintiff that's suing you. But for most of our clients that need an estate plan, they part of the subject sometimes makes our clients uncomfortable, because now they have to think about, in the event of their passing, once they die, what's going to happen. So that makes them uncomfortable. But most of our clients actually believe it or not, enjoy the interaction with a estate planning attorney, because most estate planning attorneys, they're a fiduciary. They're supposed to be a fiduciary, and like I said, most are, because they're supposed to be a fiduciary. So estate planning attorneys that are licensed should be giving their clients advice in their best interest, because they're required to as a fiduciary. But unfortunately, there are some professionals that are supposed to be fiduciary that do not provide fiduciary advice. So yeah, but we highly recommend for our clients to consult with like I said, with an estate planning attorney. A lot of our clients will find other services, for example, like LegalZoom. There's like 5 or 10 different companies that provide self-help services. And for example, with LegalZoom, LegalZoom is a very large company, and LegalZoom's model is like Home Depot. You basically do it yourself, which for most of our clients, they don't have the expertise in estate planning, and so we don't recommend that they do it themselves. LegalZoom has expanded where they have a hotline, and you call their hotline and talk to a licensed attorney. So some of our clients do use services, for example, with LegalZoom, but we often recommend, if possible, just hire a law firm with an attorney that specializes in estate planning. And some law firms, that's all they do is estate planning. Some law firms, the larger ones, they might have certain attorneys that specialize and their expertise is in estate planning. And in some law firms, you have the attorney that does a little everything. So often when our clients call us and they ask us, should they consider this attorney, part of our job as their fiduciary, as an investment advisor, is help them to do the due diligence. So we would often do the research. We would reach out to the attorney or the law firm and ask them questions, to find out their experience, their expertise. There's certain designations when it comes to a estate plan that will tell us if they have extensive experience or expertise in estate planning as well. So that's the summary of my presentation. John, if it's okay with you, we could open it up for Q&A.
Yeah, wonderful. Thank you so much for the presentation. That was Very informative. I'm sure people have some questions. So as I mentioned before, if you'd like to ask a question over voice chat or video, just use the reaction at the bottom of the screen for raising your hand, and I will call on you and ask you to unmute. But we do have one question, at least in the chat. You can also throw questions in the chat, and I will ask them for you. We did have a question from Steve G, who said, how much do these attorneys charge for a living trust?
So that's a great question. It varies. For example, I know on one of the freeways or several of the freeways when I'm driving, and when I drive, I try to pay attention to the road, but often my colleague or the passenger right next to me would point it out. Or sometimes when someone's driving and I'm in the passenger, I'll look and I'll see in the billboards, and I don't know those. I don't remember those law firms in particular, but one law firm would advertise, get an estate plan or file for bankruptcy for $500 to $1,000, or receive a living trust for $500 or $1,000. So there's a broad range, and we often tell our clients the cost of the estate plan depends on how complex your estate plan is, but generally for most clients, it's going to be oftentimes either a single person or a husband and wife, or a participant and their spouse. If it's just the two of them, and they have one or two child, and one for example, one real estate property, which is their home, generally most attorneys are going to charge about $1,000 to maybe $3,500 for an estate plan. From our experience, if you're paying, like I said, $1,000 to $3,500, that's reasonable, depending on the attorney's expertise, depending on how complex your estate plan is. What we've seen, some of our clients pay over $5,000, over $10,000 for an estate plan as well. So it really depends on how complex your estate plan is. But that's a great question.
Wonderful. We also have a question in the chat from Helen L, which is how to set up a charitable account, and what amount would you suggest that they fund it?
That's also a great question. So there's different types of charitable accounts. For a lot of our clients, probably one of the most efficient types of charitable accounts is what we call a donor advised fund. And with a donor advised fund, you often could establish the donor advised fund through a large brokerage like Fidelity Investments, or for our clients, we custody at Charles Schwab. So we're able to establish a donor advised fund for our clients at Charles Schwab. And with the donor advised funds, it provides you with a lot of flexibility, and I'll just generally go over it. So the discussion that we often have with our clients, when it comes to donations, because we all want to help, and helping is very important, but there's also benefits in helping, other than taking care of our community and taking care of our charities. There's what we often tell our clients, for example, there's tax benefits. So with a donor advised fund, generally how it works is our clients able to donate whatever amounts they're comfortable with, and get a tax deduction for that year, and it goes into the donor advised fund, and that money no longer belongs to the client, but they still have limited control. And the control that they have is they could direct Charles Schwab or Fidelity, whoever custodies the donor advised fund, to make a donation on their behalf to certain charities that are accredited and approved every single year, with any particular amount that they have in mind. So for example, one of our clients might set up a donor advised fund and set aside $5,000 or $10,000 or $100,000 to contribute to this donor advised fund. And the nice thing about it is, like I say, they have limited control, where they're able to actually say, okay, this year I want to give $10,000 to American Red Cross, and then the rest of the money would remain in the donor advised fund. And then next year they could say, okay, I want to give $5,000 to the Salvation Army. So it provides that flexibility where you're able to help the community and help these charities, and at the same time have some control. And we tell our clients, helping is great, but we as a fiduciary, our clients' interest is always our what we have in mind, and how it'll benefit them as well. So that's a lot of times for our clients, unless our client has more substantial assets, then some clients would set up nonprofits, some clients would set up private foundations as well. So, but that's an excellent question as well.
Wonderful. We also have another question in the chat. Sorry, let me expand it here so I can read it easier. From Pat R. We have a request to please comment on inheritance protected / asset protected trust. And then I have additional material here. It protects your beneficiary in the event of a lawsuit. My daughter beneficiary is an MD and can be sued at any time, and also protects her in the event of divorce. The inheritance goes to her, not in law. Will this type of trust be effective?
Wow, that's an excellent question. Unfortunately, for those webinar, due to the limit time restrictions, because when it comes to those types of trusts, it's very detailed. And a lot of times, it's like I said, we as an investment advisor, we give general advice. We don't give legal advice. And when it comes to those types of trusts, I would highly recommend that they could contact us, and we could have the discussion and possible consultation with their estate planning attorney, or if they don't have one, we could refer them to one, because those types of trusts are actually very specific. And for our clients, there's a lot of ways that an estate plan and living trust could protect your assets. And like I said, it's a little bit more specific, where we often don't like to have those detailed discussions unless we have a thorough understanding of the client or participants financial situation. But that's an excellent question, and if she reaches out to me at I'll be happy to coordinate and join in on a discussion. But due to the limited time, and it's that topic is very advanced, where a lot of people might not be interested. So please contact me, and we'll have that discussion at a later time.
Wonderful. I should note as well that the Logic Wealth Management website and your cell are both right there on the slides. We do have a question from Doris, which is, once the trust is in place, how often should you do a trust review?
That's a great question. With our clients, we often talk to them on a regular basis, where our service is essentially on demand. So whenever a client has a question, or in a lot of life events, for example, any births, any deaths, any divorce, any life-changing circumstances, such as a job, transition a job, we often are very proactive with our clients in having those discussions. But generally, we'll tell our clients to, after having the discussion with us, then get in contact with their estate planning attorney, and at minimum, at least once every 5 years, have a review, with their estate planning attorney. And if needed, a lot of estate planning attorneys will help the client amend their estate plan, amend their living trust when needed. So a lot of times clients will ask us, "Hey, David, I'm fairly young. I'm in my 20s. I'm in my 30s. I'm in my 40s. I'm very healthy. I don't think anything's gonna happen to me for the next 20, 30, 40 years. I probably don't need an estate plan." But we often tell them, well, you should have one, because one, you have substantial assets, or you have a decent amount of assets. Two, you have beneficiaries, your spouse or kids that you want to take care of. And then three, if you have real estate, you should have an estate plan, including a living trust. And even though the probability of something happening to you at your age, in your 20s, 30s, 40s, is not very high, having an estate plan, having a living trust in place helps. And then throughout the years, as things change, like I said, in the event of a death of a loved one, in the event of a birth of another child, or when those events come along, we all often have the discussion with our clients, and then that's where we tell our clients, you should get in contact with your estate planning attorney, and consider doing an amendment. So.
Wonderful. Well, yeah, if there's any other questions out there, again, feel free to raise your hand in the Zoom or just put your question in the chat and I'll read it out. We'll just wait a few moments here, see if any other questions come in. But David, thank you so much for joining us. It's a wonderful and very informative presentation. I'm sure it's going to be highly valuable to our members. I should mention again to everybody that the recording of this presentation is going to be available on RELAC's website, YouTube, and we'll send it out over email to everybody. If any questions come up, you can certainly email us, admin@relac.org, or I'm sure if you go to logicwm.com, they have a contact pages there as well. But if we get any contacts, we'll certainly direct them over to you, David. But yeah, if we have no further questions, I just want to thank you for making the time to be here with us today. We do actually have a question from someone here. I'll ask you to unmute. If you want to unmute and ask your question, we can go ahead and get that in here.
Yes, good morning,
there.
David.
Hi,
Good morning, everybody. Can you hear me?
Yes, we can hear you.
Okay, thank you very much for your exposure to this topic. I had a living trust on my primary residence and my wife, and I have adult children. I'm not trying to get specific advice or consultation from David or from anybody else, but I just want to get how specific could I be if I were to include all my finances and all of that under this estate planning. If I were to include all my bank accounts and all of that, would that be advisable to include part of the estate planning? Thank you.
Actually, that's an excellent question. Yes, a lot of times when our clients meet with an attorney and have the discussion with us, we would tell them, what accounts, what assets should be, we say retitle or named for the living trust. For example, generally real estate. If you own a home, at some point, if you have a living trust, you should definitely retitle your home into the name of the living trust. For example, in my case, when I bought a real estate property, I just held title, David Chung, and then once I formed my living trust, I had my estate planning attorney prepared a deed where I'm able to transfer it into my living trust, and that's probably one of the bigger benefits of the living trust is that in the event of my passing or incapacity, my living trust is actually the legal owner of the real estate or home, and in the event of my passing or incapacity, the successor trustees that are named in my living trust, they're able to take immediate action. They're able to proceed in the distribution. They're able to take, they have the legal powers where the cost is not prohibitive and there's no delays. So with a living trust, it's like I mentioned during this presentation. Oftentimes, it's important, especially when you have real estate and you have kids that are under 18, and if you have a living trust, then that's where I mentioned you should retitle all your real estate properties into the name of your living trust, and then depending on the type of account. For example, with all of our, I'm guessing most of our participants here and all of our County of LA clients, active or retirees, when they have a 457 or 401k, they often ask us, "Hey, Dave, I want to retitle my 457 or 401k into a living trust." With retirement accounts, you're not able to retitle that account into a living trust. But what you are able to do is you're able to name those account as a beneficiary. But like I mentioned during the presentation, that's where it depends on the detail, and we have our discussion, with the participant or client, where it might make sense for them to name their spouse as a primary, beneficiary for their 457 or 401k, and then name the trust as a contingent beneficiary. Or if they don't have a spouse and they don't have any particular person in mind, and they just want to give, instead of naming, if they don't have a spouse and for example, they have 5 beneficiary family members, charities, they could name each beneficiary family member 20% beneficiary in each. Horizons Empower does allow you to do that for your 401k or 457. But in the event where one of those beneficiaries is a minor, that's where you might consider naming the living trust as a primary beneficiary. So like I said, it depends on the situation and details of the participant or client situation. And then when it comes to certain investment accounts, for example, if you have an individual account at Charles Schwab or Fidelity, or a joint account at one of these firms, or Bank of America or Chase, wherever you have your accounts, we often tell our clients, if it has substantial assets, and every client's definition of substantial assets is different. So some of our clients would tell us, David, my Bank of America account only has $2,000. That's not substantial enough for me. So I'm not going to go through the trouble and the process of retitling my joint account or my individual account at Bank of America into the name of my living trust. But some of our clients will do that, and a lot of financial institutions, once you have a living trust, if you provide them with certain documents of the living trust, then for example, with Charles Schwab, with Bank of America, with Fidelity, they'll provide you with paperwork where they'll allow you to retitle that account. If they don't allow you to retitle that account, they'll open a new account for you where, before I had my living trust, my account was, David Chung individual account or David Chung joint account. But after I established my living trust, I was able to retitle my Schwab accounts to the David Chung Living Trust account at Charles Schwab, for example. So that's an excellent question. So a majority of the time when the attorney's helping you establish the estate plan and living trust, they'll have that discussion with you. But then most attorneys, they won't help you with that process. And that's where our clients would have us, since we're part of the discussion, we're part of the meeting, that's part of our job as an investment advisor to help them with the process, to have that discussion with them on which accounts should be in the name of the living trust. And the most important thing is, if it's not in the name of living trust, please, I highly recommend for everyone to check your beneficiaries, because we often meet with our clients where they're, for example, at Lacera, even if you're active or retired employee, you still could name beneficiaries. And oftentimes, either with the Lacera account or the 457 or 401k account, we often meet with, a County of LA employees where they have their one of their parents or both of their parents as a beneficiary, and they named the parents 10, 20, 30, 40 years ago, and unfortunately now the parents have since passed, or sometimes they'll name a spouse as beneficiary, and unfortunately now the spouse is no longer with them, and now it's an ex-spouse. So we highly recommend that along with us helping the client, that each county or each participant reviews their beneficiaries, whether it's with Lacera, with your 457, with Empowered, or your 401k, and all your other accounts. Because with most of these accounts, you can name a beneficiary. The disadvantage with a home is you could have a will that you list in your will. In the event of my passing, I give my home to my wife. It will allow you to pass the home to the beneficiary's name on the will. But unfortunately, it doesn't avoid the probate process. It doesn't minimize the probate process. So if you don't have a living trust and you own a house and you do have a will, the court or the judge might honor the will, but you still have to go through probate. And like I mentioned during the presentation, probate, unfortunately, cost is fairly prohibitive, and the time to go through the probate process, depending on the county, can take 6 months, can take a year, can take a couple of years, and that's why we have very few clients that joke with us, and sometimes they follow through with it, where they tell us, Dave, I have a substantial amount of assets. I have family members. I'm not married. I don't have any kids. But in the event of my passing, I'll let my family members, deal with my estate. and so a lot of times we'll talk to them, and at some point they'll obtain a estate plan and a living trust. But like I said, there have unfortunately been events where our clients do pass without an estate plan, unfortunately without a living trust, and now their family is in contact with us, their beneficiaries in contact with us, where we have to help them, through the process, with advise them through the process. And at least with our clients, we have them name the beneficiaries at Lacera with their 401k, with their 457. So a lot of those assets don't go through the probate process. But unfortunately, with a home, there's no way to minimize or avoid the probate process unless you have a living trust. So that's an excellent question. Thank you.
Thank you, David.
You're welcome.
Wonderful. We have just a few more questions here in the chat. I want to let everyone know too that we will have to, it's only going to be for an hour. So we'll have to wrap up at the end of the hour here, but we have a question from Ricky in the chat here, which is, if you decide to amend a trust yourself, does the amendment need to be witnessed / notarized?
That's a great question. Our understanding is when most living trusts, it has to be notarized. When it comes to living trusts, for example, when we sit in the consultations with our clients, with an attorney, and then throughout the consultations, most attorneys will provide several consultations. Like the first consultation is just to provide information and advice on the benefits of an estate plan and living trust. Very similar to this presentation, but these attorneys, they're licensed and they're experts in this field, so they'll go more into detail in the participant's particular situation, and then after they'll work with the client or participant in designing their estate planning living trust. And then usually the last step of the process is they'll have they have created the estate plan and living trust, and they'll meet with our clients. And we often, especially with the living trust, my understanding is it should be notarized. With wills, our understandings, wills can be witnessed, but like I just mentioned during the last question, that if you own real estate, it will might help you pass along your home to your beneficiary, but unfortunately, it won't minimize and avoid the probate process. So it's always, depending on your situation, is always, safer to like we recommend for all of our clients to consult with an attorney. Some clients, they choose not to, or some clients don't have the financial means to do so. So some clients will, use LegalZoom or one of these do-it-yourself, services for estate planning. And then some clients would just go online and download documents and just pay, $25 or $10 for a document. But the benefit in consulting with the attorney is it's a very similar benefit that our clients receive in consulting with us, is that they're the experts in estate planning, just like we're the experts in investment advisory and money management, where due to their license, due to their experience, due to their knowledge, they are considered experts because they have years of experience in helping numerous clients, and also their license, which is the most important thing. So that's an excellent question. Like I said, generally most living trusts should be notarized, and most wills can be witnessed. I think the minimum is at least 2 witnesses, but most competent estate planning attorneys, when they put an estate plan together for a client, like I said, it can include a living trust, or sometimes if you don't own real estate, if you don't have any kids, if you don't have any special needs children, you might not need a living trust. But that we often tell our clients they still need an estate plan, which often would just include a will, financial power attorney, and healthcare directive. And if they have a spouse, then they'll have 2 wills, 2 financial power attorney, and 2 healthcare directives. But that's an excellent question.
Wonderful. We probably just have a time for just a couple more questions here, if anybody has them. But Steve in the chat has asked, since Empower and Horizons is getting rid of 2 of their best investment funds, the small cap and mid cap equity funds, where should we invest our money?
That is actually a question for our expertise. As investment advisors, as a fiduciary, we spend the majority of our time managing our clients' money, and that's an excellent question. It depends on your overall finances. So if Steve wants to reach out to me through our website or text me on my cell phone, I'll be happy, to provide, because we generally don't give in just general investment advice. We have to have a little bit more understanding of the person receiving our investment advice. But we always tell LA County clients that Lacera is gold. There's nothing better than Lacera. Horizons is actually very good as well. Horizons is good, where you're able to contribute to the 457, the 401k. The county provides a match. Oftentimes it's up to 4%. So we encourage our County of LA clients to contribute to Horizons, if possible, max out the Horizons, and then when it comes to the specific investments, that's where we will have a discussion with them. Horizons funds in general are decent funds. We custody our clients' assets at Charles Schwab because Schwab is more efficient. The joke I have is Horizons good, but Schwab is better. And that's why we choose to have majority of our clients' money at Schwab. But to answer that question, in a little bit more detail, we were also notified by numerous clients that the small cap and mid cap fund were combining into one fund. We are not big fans of that combination. If any employee wants to, they're able to when you log on, the next time you log on to your Empowered account, you can look to the left, and there's a feature that's called brokerage. Within Empowered, any County of LA employee has access to, with a 457 or 401k, to this brokerage feature that allows them to set up what's called a self-direct brokerage within their Empowered 457 or 401k account. And that self-direct brokerage feature actually allows them to establish a sub-account that's directly with Charles Schwab. But that's very complex. We do not recommend that the average county employee establish that self-direct or PCRA account through Empowered with Charles Schwab, because once you establish an account and once you move that money to Schwab, you should work with a professional like us, because at Schwab, at Fidelity, at any of these firms, you could buy, pretty much any investment out there. And unfortunately, some of our clients that they get into stock picking and day trading, and they're able to risk and essentially lose all their money in their 457 or 401k with Empowered, where with Empowered funds, they're safer. But like I mentioned, we were not big fans when we found out that the small cap and the mid cap were combining, because we specifically recommend a specific small cap and a specific mid cap due to the efficiencies of those ETFs or mutual funds. But unfortunately, you can no longer buy a small cap through Empowered. You would have to buy it through Charles Schwab through the self-direct PCRA feature within Empowered. So if anyone wants to, they could contact us, and we'll have that discussion with them. And depending on their goals, their investment objectives, their asset class, their time horizons, then we could advise accordingly. But excellent question. Do we have any more questions?
Yes, I'm so sorry. I had to jump off for just a second there. I think we have time for just one more here, and I see the next one in the chat. And obviously, if we miss anybody's questions, do feel free to contact David directly. I'm sure he'll be able to help you. But Ricky has asked, do you happen to know why Empower and Horizons eliminated certain funds? We were never given an explanation.
That's an excellent question. We did not understand why they did it either, because a lot of these Horizons funds are very large funds. That what we do as an investment advisor, as a fiduciary, is we do a lot of due diligence on the funds. Where and I'll give you an example. The average mutual fund in the industry, the expense ratio is about 1%, which like I said, it's average. It's not terrible, but it's not good either. But with Horizons, with Empowered, the average expense ratio for their funds is about 35, 40 basis points. So when you're buying a 457 or a 401k fund through Empowered, you're paying oftentimes less than half of the industry average, which is awesome. Like I said, nothing's better than Lacera. Lacera's gold. Horizons is decent. With our clients, we often manage their money through Charles Schwab, either directly at Charles Schwab once the client with LA County retires, or while the client's working with the county, we help them set up the PCR feature. The reason why is at Charles Schwab, if you know what you're buying, if you have an expert and a fiduciary like us, we could buy the same small cap, the same large cap. Well, actually, I apologize. The large cap at Horizons is their most cost efficient fund. So we could buy the same small cap, the same mid cap, the same international, the same bond fund, but usually at 1/10 of the cost. For example, the small cap expense ratio is about 40 basis points, where we buy the same small cap ETF or mutual fund through our client's account at Schwab, and it's about 5 basis points. So in that example, apples to apples, you're getting the same fund, whether it's at Empowered or through Schwab directly or through Schwab PCRA, but you're paying 8 times less. Because with Schwab, if you know what you're buying, for our clients, we manage over $220 million at Schwab. Our clients' assets have been custody at Schwab and TD Ameritrade over the past 20 years. So we're very aware of all the investments out there. We've done our due diligence on them. And in this case, like I mentioned earlier, I wasn't a big fan of them combining those two types of accounts, with small cap combining with the mid cap. But unfortunately, there's nothing you can do. So our understanding is by the deadline, if you do hold a small cap, it'll become a small cap / mid cap. Or if you do hold a mid cap, then it'll also become a small cap, mid cap fund. And we thought it should be separate because in our client's portfolio we have it separate investments depending on the client's needs. But if you want to talk specifically in regards to your investment, if you reach out, I'll be happy to have that discussion, or one of our other advisors could have the discussion. So we appreciate LA County employees. We're very, very fortunate to have expertise and over 20 years of experience servicing LA County employees, and that's why if anyone has any questions, we're always happy to talk to you by phone, to sit down with you, to answer your question. Depending on our understanding of your finances, we can give you specific recommendations. There's a minimum standard. It's called a suitability standard that all financial advisors should have. And with a suitability standard, it requires the financial advisor to have a thorough understanding of the client or participant's financial situation before they give advice. So that's why often in these webinars, I cannot give you a specific recommendation because I don't know your financial decision. I don't know your risk tolerance, your time horizons, your investment objective. But once we provide that consultation, we often will understand your finances, where we would be very comfortable knowing what's suitable for you. But like I said, what makes us different is we choose to be a fiduciary, and being a fiduciary, it's where we'll tell you this recommendation is not only suitable for you, but it's in your best interest. Why? Because it's more cost effective, it's more efficient. Basically, you're going to benefit a little bit more than going with, for example, and I joke with a lot of my colleagues that work at Morgan Stanley and Bank of America. Some of them choose to be fiduciary, but unfortunately, some of them are not fiduciaries, and that's where you can have a discussion with them or us on the benefits of working with a fiduciary versus just working with just your regular financial advisor. So.
Wonderful. Well, thank you so much, David, for joining us. And thank you all for joining as well at home. This has been a RELAC webinar with David Chung of Logic Wealth Management. David has his contact information there on the slide. And you can also contact us at admin@relac.org, and we'll pass along any inquiries. Keep an eye out on your email for more member communications with more exciting webinars that are upcoming. We're going to be doing these a lot more often. But David, thank you so much for joining us. We really appreciate it. And thanks for all the great information.
I want to thank you, John, and everyone that joined. It was a pleasure. We enjoy, helping LA County employees. We appreciate your service to our community, and we're always here to help. So I wish everyone a great day.